There has been many rumors in this community that the ad building and the clubhouses have been hijacked from our non-profit corporations. What looks like to be a slip of her tongue by PCM's legal affairs officer, she claims that our clubhouses are owned by GRF. This inner circle team is pretty slick, and they might have figured out a way on how to steal our resources away from the shareholders. Watch the video and see if the inner circle has committed a crime.
I want to respond to the gentleman who stated actually, that PCM has a vested interest in taxing and spending by the mutuals. That's completely incorrect. PCM's fee is based on a per door fee. There's no relationship whatsoever to what the mutuals or what GRF spends and what they sell or what they purchase. GRF does own the clubhouses. They're located in 3rd and United. GRF owns its facilities. They aren't owned by the mutuals. Just wanted to make that clear. And then also, if the directors can remember to turn off their microphones when they're not speaking, we do get feedback. The people at home listening get feedback when we don't remember to do that. So,
thank you, Chris, for clarifying a lot of that. I would, however, challenge you on the fact that GRF owns its own facilities. I believe that actually the mutuals own all of them, but I could be wrong. In any case, I would...
As United President Pat English comments that she believes the ad building and clubhouses belong to the mutuals. How could GRF own these facilities when this property belonged to the shareholders in their mutual nonprofit corporations? The state of California and the Internal Revenue Service have codes and regulations for any property transfers. You must have a 2/3 vote of the membership to transfer or sale of any part of this nonprofit property. We want to see documents that support your statements. How could you possibly purchase any mutual property when 90% of all your funding comes from the mutuals? That's our money, not yours. If this board took money out of the trust to purchase this property without a shareholder's vote, then you will become another City of Bell, and can look forward to 12 years wearing orange suits. I hope you didn't raid the reserve. Here are the legal aspects of the use of reserve funds.
I'm Sarah Hashim-Morris in the Los Angeles Times newsroom. A Los Angeles Superior Court jury has found former Bell Assistant City Manager Angela Spaccia guilty of conspiracy and corruption charges after nearly 5 weeks of testimony and on the 10th day of deliberations. Spaccia was found guilty this week on 11 of 13 felony counts, including misappropriation of public funds and conflict of interest. She is the 7th official convicted for her role in the city's corruption scandal. The Times reports that, according to prosecutors, Spaccia probably faces a sentence similar to the 10 to 12 years in prison that her former boss, Robert Rizzo, is expected to receive. Rizzo pleaded no contest to 69 corruption charges in October. Spaccia alleged that Rizzo was to blame for the corruption scandal. She did, however, admit that her $564,000 annual salary was unethical, but not illegal. Los Angeles County District Attorney Jackie Lacey called the verdict a bittersweet victory for Bell residents, saying, "I'm pleased the jury viewed this extremely complex case precisely for what it was."
July 12, 2009. This is a review of a column called "The Association" of the Los Angeles Times. The author and attorney illustrates the reserve fund and their legal uses. The author states that decorative items and the regular routine maintenance of major components should be part of the association's day-to-day operating budget, funded by regular monthly assessments. When a board uses money from its reserve account for regular maintenance, it is breaking the law, as reserve funds are collected and earmarked for a specific purpose. Given your board director's remarks, it appears that he is misinterpreting the law and thereby misusing the reserve funds, exposing himself and the board to liability. According to the Davis-Stirling Act, Civil Code Section 1365.5, borrowing from the reserve account requires adherence to strict procedures. As a general rule, Associations are forbidden from using reserve funds for anything but the repair, restoration, replacement, or maintenance of major components or litigation involving such projects. Money may be borrowed from the reserve fund to meet short-term cash flow requirements or other expenses, if the board has provided notice of the intent to consider the transfer in a notice of meeting. That section also requires that the notice include the reason the transfer is needed, some of the options for repayment, and whether a special assessment may be considered.
Where did the funding of the clubhouses come from? Remember, GRF lost their nonprofit tax exemption. Let's take a look at exactly what the ramifications are for GRF to lose their nonprofit 501c4 exempt status. GRF 501c status is revoked retroactively with an effective date January 1, 2013, the due date of the 2012 Form 990. There may be serious and expensive consequences at the state level, including, but not limited to, sales and property taxes, payroll and unemployment taxes, and workers' compensation, as well as thorny issues with the State Department of Charitable Solicitations. This list only scratches the surface of the problems facing GRF. The shareholders have a legal right to dissolve any future business with GRF,